Ladies and gentlemen, I can say dear friends because in this day and a half I have old and new friends here with us. As Professor Schmidt mentioned yesterday in the opening ceremony, 2 years ago the Swiss Institute of Comparative Law invited to Lausanne a group of leaders representing the main religious communities in Israel. At the Institute, we have a team of experts of the different legal systems of the world. We also have a precious comparative law library that includes a unique collection of religious books. Tomorrow afternoon, after a tasty kosher light lunch, we will have the pleasure of showing you the Institute, explain you exactly what we do, and of course you can visit our library where a little surprise will be waiting for everybody. Now, to come back to the religious leaders, this group was composed of 25 religious chiefs representing the Druze, Muslim, Christian and Jewish communities in Israel. And the fascinating characteristic of this group was the fact that they studied law together in the framework of a special program offered for them by an Israeli law school. And this is a splendid example showing how the study of law can contribute to interreligious dialogue. Indeed, despite the initial prejudices, suspicions, and even antagonism, when the group started their studies, after 3 years together, many of them became close colleagues and even true friends. But, on the first place, why would these religious leaders wish to study law in Israel? The reason was that many, or most of them, were acting either as judges in religious courts or as officers in the Israeli administration, dealing with matters related to their respective communities. Therefore, alongside Jewish, Muslim, Druze, Christian religious laws that they were familiar with, it was important for them to acquire a background in Israeli law, the law of the land. And that is why this group was constituted there. Now, since these leaders studied Israeli law, we at the Institute believed that it would be a good idea to offer to them a comparative overview of the problems posed when religious rules have to interact with state law in other legal systems of the world. Thus, during the first part of their journey in Lausanne, the leaders held presentations dealing, for instance, with religion at the workplace in Holland, religious symbols in Italian classrooms, Islamic dress in France, participation of Muslim girls in swimming classes in Switzerland, issues related to civil and religious marriage, divorce in different countries, the place of religion in China, in the USA, the prohibition to build minarets in Switzerland, and other related subjects. These presentations were followed by a discussion of the position that religious rules have, or should have, if at all, within the legal system of a state. As a background to the discussion, we presented to the leaders the famous pyramid of Kelsen on the hierarchy of norms. As we know, according to Kelsen, the hierarchy of the sources of law is usually composed of the Constitution, followed by qualified or organic laws, then by ordinary laws, and lastly regulations, ordinances, municipal legislation, case law, jurisprudence, custom, etc. This being the case, we asked the leaders, where would you place religion in this configuration? Indeed, in most modern countries, religious norms, defined as the normative expression of an almighty divinity or entity, are not by themselves a recognized source of law. It is true that in some states, religious norms are applied in certain fields. In Israel, for example, Article 2 of the law of rabbinical courts provide that marriages and divorces of Jews shall be celebrated in Israel according to Jewish law. And this seems prima facie to be a reference to the halakha. In this case, however, Jewish law is applied not because Israel is a theocratic state, which of course it is not, but because the reference to Jewish law was introduced into the Israel legal system by means of a legislative act enacted by the Knesset. In other words, religious law was adopted in Israel through the channel or through the filter of parliamentary legislation. When a state adopts religious norms by means of legislation, those norms become part of the state's legal system, as is the case of any other legal norm. Consequently, the adopted religious rule must accommodate, must interact, must be implemented in conjunction and in harmony with the other existing legal norms. And it is for this reason that, for example, some decisions of the Israeli rabbinical, Muslim or Druze religious courts, as Judge Jubran said brilliantly yesterday, may be challenged before the High Court of Justice in Israel, the Bagatz. This may happen, for example, when one or the other party claims that his or her fundamental rights were violated in the course of the procedures before a religious instance. And indeed, in many cases, the High Court of Justice of Israel was called to intervene following judgments rendered by religious instances. Another feature of this interaction of religious rules with state law, this time at the institutional level, is evident from the fact that, in general, not for everybody, but in general, the salary of the judges sitting in religious courts is fixed by the State of Israel. For example, Article 20 of the Law on Druze Religious Courts of 1962 state that the salary of the Druze judges shall be established by a resolution of the Knesset. So also in this rather technical field, we can see how cohabitation works there. We will be able to hear tomorrow from Professor Englard and Martin Sishow more details about religious law and secular courts and about the situation of religious tribunals in Eastern Europe especially. The two examples that I mentioned show how state law and religious norms exist together in Israel, even as we all know, cohabitation may often become quite turbulent. But the need to reconcile religious rules with state law does not arise only in Israel, of course. Let us take the field of marriage. Some states allow people to marry following the forms and procedures prescribed by their religion. However, the status attributed to religious marriage is not the same in every jurisdiction. I shall refer to three examples. Example number one, Israel. In Israel, marriages can be concluded under the forms provided for by the recognized religious communities. For so doing, each religious instance has jurisdiction when both future spouses belong to the same community, a Jew with a Jewess, etc. So, grosso modo, because nothing is of course totally black or white, grosso modo it can be said that in Israel, only religious marriages can produce legal effect. Example number two, Switzerland. Switzerland allows couples to celebrate religious ceremonies, but only after a civil marriage has been legally concluded before the civil authority. This is because in these countries, civil marriages are the only ones that can produce legal effect. Compared to Israel, this is a different form of cohabitation because in Switzerland, religious marriages are tolerated, as the Swiss like to say, but only as a ritual ceremony, not producing legal effects. Example number three, Spain. In Spain, the state signed agreements in the 90s regulating the relations with the Muslim, evangelical, and Jewish communities. On the basis of this agreement, marriages celebrated according to the respective religious procedures of these three communities can produce full legal effects in Spain. Therefore, in Spain, a person has the right to marry either following the civil or the religious forms, but he must choose only one and cannot celebrate both. Of course, if we compare the situation in Spain with the situation in Israel, we can see that there are some similarities. For instance, as in Israel, the religious authorities in Spain cannot infringe state norms of a superior hierarchy. Thus, even if Muslim or Jewish laws allow the conclusion of marriages at a very early age, the Muslim or Jewish authorities in Spain are prevented from celebrating such marriages in contravention of the fundamental norms of marital capacity established by Spanish civil law. In the same way, the Spanish Muslim authorities cannot celebrate polygamist marriages. So here we can see three states that have adopted three different philosophies of cohabitation with religious norms. In Israel, religious marriage is the only form accepted. In Switzerland, only civil marriage produces legal effects. While in Spain, one can choose whether to marry civilly or in the form prescribed by his relation. And this happens when religious law, customs, or tradition have been formally incorporated into a state's legal system by means of legislation. In recent times, however, many countries are facing a new phenomenon. Due to the diversification of societies, the so-called multiculturalism, certain segments of the population demand the application of religious norms in areas where parliaments have not formally incorporated these practices. The claim to apply religious rules, tradition, or customs may concern almost any field of life, from birth to death, from abortion to euthanasia, passing by excision and circumcision, from marriage to divorce, from workplace to dressing codes, from food to medical treatment, from religious symbols to the building of temples, from education to service in the army, etc. And this multiplicity of fields increases even more the risks of conflicts with state law. The danger of conflicts escalates with the proliferation of some types of less institutionalized religious movements. As examples, the Swiss Intercantonal Center for Information on Religions cites Scientology, some esoteric groups, the Catholic Charismatic Renewal, and diverse healing groups, the widows. By adopting such Solomonic approach, the Spanish judges recognized implicitly the validity of polygamous marriages, legally concluded abroad, and applied what we call a mild or a non-strict conception of the principle of public order. The same reasoning was applied with respect to the validity of the talaq, the Muslim unilateral divorce. A court in Murcia, in Spain, held that the fact that unilateral divorce may in principle hurt the right of the woman does not mean that Spain will automatically reject all cases of talaq. For instance, if in a specific case the divorce would be in the woman's interest, for example, because her husband discriminates her against with respect to his other wives, then I imagine the exception of public order would not be strictly applied and the foreign divorce would be recognized. This reasoning may apply if, in a Muslim talaq, the rights of the woman are not violated. For example, if the intervening instance in the divorce was not biased, if the woman had a fair opportunity to be heard during the proceeding, if her economic rights were respected, etc. Then there is no reason to reject the recognition of the Muslim divorce. This shows in a nutshell the possible conflicts that may loom when a problematic situation is imported from abroad. A different case is the one of situations that are not imported, but that are created within the jurisdiction of a given state. For instance, would Germany recognize the civil effects of a marriage celebrated in Berlin according to African or Polynesian tribal forms, or according to the Romani tradition? Or would Italy allow Iranians to divorce in Italy according to a law discriminating the wife? This case arose in 1991 when a court in Milan had to decide whether or not to apply Iranian law to the divorce of an Iranian couple that was resident in Italy. Article 1133 of Iranian civil codes provides a man can divorce his wife whenever he wishes to do so. The Italian court rejected the application of this provision, stating that it conflicts with the principle of equality of rights consecrated in the Italian constitution. This case contrasts with the conception that the principle of public order shall not be applied strictly in every case, especially when the wife has an interest to divorce from that bad guy that beats her. In recent years, European states have been confronted with questions related to Muslim hardscape at work and public spaces, to participation of girls in sports and swimming cases, to religious symbols in public places and institutions, to praying in the workplace, to sexual mutilation of girls, recently of boys. More recently, new subjects are emerging, and we know that the European states and institutions face a serious problem, perhaps because they lack of experience or of perspective to deal with many of these issues. So European legislations start to wonder, would it be appropriate and constitutional to enact a law in order to criminalize the burqa? And if yes, will such law be applied in the field? For instance, how will the authority identify the person hiding behind the burqa in order to pursue her? Or how would such a prohibition affect the tourism industry? We know that here in Geneva, if you come and visit in the summer, you will see a lot of very rich people coming from the Gulf states, and many women wearing this kind of headscarves or however, whatever. So that would be a severe injury to damage to the Swiss tourism industry, for example. Or they ask, should we forbid praying in the streets, or should we prohibit to put religious symbols in courtrooms in Europe? I can imagine a Muslim that has to be judged by a criminal court where there is a cross or another religious symbol. He will not feel very comfortable being judged there. Should we forbid praying in public places? Look what Paris municipality had to do lately due to Muslim prayings in the street. Or would it be appropriate to legislate in order to ban the construction of minarets? The recent decision rendered by a German judge that could outlaw religious circumcision created a serious concern in some hospitals and medical circles, even outside of Germany. Following that decision, for instance, the Children's Hospital in Zurich discontinued circumcisions in order to review its policies. This interruption was stopped 1 month later. Being jurists and advocates, we shall know that it is quite rare that a decision rendered by a court in one state would have such an impact in another state. And this shows the level of concern, of sensitivity that religious matters are acquiring in Europe. We will learn more in detail about the situation in particular countries during the roundtable that will follow the coffee break, and also this afternoon. In this rather sensitive context, we may need to pay attention to another aspect of the subject. There are cases in which issues related to state law and religious norms are diverted in order to promote agendas that go beyond the matter at stake. It was recently reported that in Norway, a proposal was raised by a laywoman acting as ombudsman for children's rights in the sense of reforming Jewish and Quranic laws. According to her proposal, Jews and Muslims should replace male circumcision by a symbolic non-surgical ritual. In this same line, it was also proposed to set the age for undergoing circumcision at the age of 15 or even 18. Having, as other person in this room, a personal experience in this specific field, I can declare my happiness that circumcision is performed 8 days after birth, because I have no memory whatsoever of any trauma or suffering. In my personal opinion, the situation would not be the same at the age of 15 or 18. The apprehension of the intervention, the fear of the pain, and the fact that circumcision performed at a more advanced stage may, in some cases, cause severe complications, could lead some men to renounce to be circumcised. Among other facts, because of the circumstance that in the overwhelming majority of cases, we can talk about a retroactive consent to circumcision. So this is the problem. This is the main problem. Now, when such types of proposals that could potentially stigmatize a religious community are raised, it could be legitimate to ask whether the intention really hiding behind those proposals that are raised under the noble flag of children's physical integrity, if there is not other intentions hiding behind these proposals. And this is exactly the worry of the Wiesenthal Center that recently launched a Norway Watch program due to this kind of proposals. Another example of these types of agendas can be taken from the field of burials. In Switzerland, as in many other countries, the Jewish communities have a long history of maintaining serene and low-profile discussion with the local authorities for being allowed to have burial places where Jewish traditions are respected. In most cases, as Rabbi El-Kaim mentioned yesterday, satisfactory arrangements were achieved. Recently, some Muslims are asking to have their own separate burial places. Of course, this can be seen as a legitimate aspiration. However, some people seem to take advantage of this fact in order to propose a total and overall ban of religious cemeteries, arguing that they are discriminatory and violate the principle of equality. I have heard one of these persons saying the following: if people were neighbors during their lives, why can't they continue to be good neighbors in death and be buried alongside the other in a non-religious civil cemetery? So here we have another example of challenging a practice that has correctly functioned during ages. In this line, almost any subject could be turned into a weapon to attack the members of a religious community. A few years ago, there was a discussion in Switzerland concerning Jewish and Muslim butchery laws. On that occasion, we could hear criticism of the shechita raised by protectors of animal rights. It was interesting to note that at the same time, that same people vehemently attacked the supposed animal suffering caused by Jewish butchery laws, but very surprisingly, they said little or nothing about hunting, which is a very old and well-established tradition in France and also in this country. And if you wander around in winter time, you will see a lot of restaurants and butcheries offering hunting menus. And one could ask, does an animal suffer more when he is slaughtered according to Jewish law than when he is targeted by a bullet shot from a distance of 50 or 70 meters by a hunter that we don't know how many glasses of wine he took before? During these debates, the dissemination of irrational stories related to certain religions attained such a level that one woman published a letter in the journal of the Association for Protection of Animals affirming that in Israel there are farms breeding red cows, para aduma, of the type used for sacrifices in the Temple of Jerusalem in order to revive these sacrifices in our time in the place where the El-Aqsa Mosque is located. Being a life member of that association and a vegetarian, I wrote to the President explaining that the noble cause of protection of animals should not be taken hostage by people having political agendas, that I do not agree, and that I do not agree that the money of my donations should be